Welcome to the fourth in the Pillars of Democracy series sponsored by the Library of Congress in partnership with the American Enterprise Institute and the Brookings Institution. I'm John Haskell, Director of the John W. Kluge Center at the Library of Congress. We live in a challenging time. Polls show that major institutions in American society, in government and in civic life, are less trusted and less respected than at any time in living memory. In an effort to grapple with the question of how their decline can be counteracted, we are bringing together historians, political scientists, legal scholars, authors, and practitioners from across the ideological spectrum. The idea is to create a fuller picture of the challenges facing American institutions and their potential promise. Last month, we looked at the Supreme Court and the federal judiciary. Today, we consider an institution whose work often occurs away from the spotlight, but which constitutes effectively a fourth branch of government, the administrative state. Regulatory actions affect us every day. We experience this in decisions made to approve vaccines during the pandemic, on environmental matters, the workplace, and in innumerable other areas of policy. Thank you for tuning in to this important conversation. Today's panel includes Beth Simone Novak, the author of Solving Public Problems: How to Fix Our Government and Change Our World, which came out earlier this year. She is a professor at Northeastern University, where she directs the Burns Center for Social Change and its partner project, the Governance Lab. Previously, Beth served in the Obama White House in the Office of the Chief Technology Officer. Jeffrey Rosen is a non-resident fellow at the American Enterprise Institute. He recently served as Acting Attorney General and Deputy Attorney General of the United States, Deputy Secretary of Transportation, and earlier in his career as General Counsel and Senior Policy Advisor at the White House's Office of Management and Budget. Mr. Rosen's expertise includes administrative law and regulation, constitutionalism, and legal institutions. Susan Dudley rounds out our panel. She's director of the George Washington University Regulatory Studies Center, which she established in 2009 after serving as administrator of the Office of Information and Regulatory Affairs in the George W. Bush administration. She is Distinguished Professor of Practice in the Trachtenberg School of Public Policy and Public Administration at George Washington University. And as well, she is a Senior Fellow with the Administrative Conference of the United States. Today, our moderator is William Galston. Bill is Senior Fellow in the Brookings Institution's Governance Studies program. He served as Deputy Assistant for Domestic Policy in the Clinton administration and has taught at the University of Maryland at College Park. He's the author of 9 books, most recently, Anti-Pluralism: The Populist Threat to Liberal Democracy. Bill also writes a regular column for the Wall Street Journal. Please note that we are leaving time for questions at the end of this conversation. You may submit your questions through the chat function on Zoom. The panelists will then be able to see them. Let me turn the stage over to Bill.
Well, thanks so much, John, and allow me to add my thanks not only to the panelists, but of all the public-spirited citizens who have tuned in today. You're in, as Ed Sullivan used to say, for a really great show. I really can't think of 3 panelists who are better qualified to talk about the question before us. And let me give everybody just a very brief sketch of how we're going to proceed and a bit as to why. Our first 3 panels have dealt with the 3 constitutionally named branches of government. But this overall series involves 10 pillars of democracy, which means that this is the first panel devoted to a pillar of democracy not explicitly named in the Constitution. And many people have wondered about the constitutional status of the administrative state. But even before then, many people who hear the phrase the administrative state won't be able to define it or locate it. It is a complex, varied phenomenon which has grown up under various auspices, relatively few of which are well known to the American people. In light of this, we've decided to proceed a little bit differently on this panel. And we're going to devote the first section of the panel to defining the administrative state and discussing how it arose, when it started, what are the phases through which it's gone, and what are the legal and regulatory auspices under which it has developed. Secondly, we're going to explore the question of the problems that have cropped up as this obscure phenomenon, the administrative state, has bulked larger and larger in American public life. This growth has occurred over a period now of nearly 90 years, and some people could trace it back even farther than that to the late 19th century. But it's not at all clear at this point what are the principal difficulties that we ought to be focusing on, or indeed whether we agree on that list of principal difficulties. And finally, in light of the first two sections of this panel, is the question of what can be done to improve the administrative state and to fix some of the problems that have cropped up. So I'm going to ask Susan Dudley to deliver the lead response on the first of these questions, namely the origins and growth of the administrative state. Jeff Rosen will take on the second of those questions, and Beth Novak the third. But after each opening statement, the other panelists will be invited to come in with additions, corrections, quarrels, new thoughts, etc. So with that, and without further ado, Susan, over to you.
Thank you, Bill, and thank you to the Library of Congress, Brookings, and AEI for hosting this and inviting me to be part of it. I like the way that you framed this, Bill, because I think a lot of people could be forgiven for thinking that Steve Bannon coined the phrase administrative state when he promised that Trump would dismantle it. But the phrase is a lot older, as is the debate over its constitutional structure. Neither of those are new. So when people talk about the administrative state, they're referring to agencies like the Department of Transportation, the Securities and Exchange Commission, the Environmental Protection Agency. Many of the laws with which American citizens must comply are written not by elected lawmakers, but by these agencies. It was not always this way. For the first 100 years or so of the Republic, it was accepted that only the legislative branch could write laws and that Congress could not delegate that constitutional authority to another branch. But that went through some dramatic shifts at the beginning of the last century. The federal government saw a profusion of new administrative agencies, especially during the New Deal, which led to heated debate over the proper role for these agencies and the regulations that they issue. What measures can we come up with to ensure they're consistent with the Constitution? And how can we keep them accountable to the elected branches of government and to the people? So what I thought I would do in hopefully just a couple minutes is highlight what I think are 4 milestones in the effort to constrain the administrative state and explain how we got to where we are today. So the first milestone was the Administrative Procedure Act. It was passed in 1946 after more than a decade of debate on the question of unconstitutional delegation. And it reflected a compromise aimed at balancing competing goals of bureaucratic expertise on the one hand and legislative accountability on the other. We have enough lawyers on this call, and I am not a lawyer who can explain this better than I can, but essentially it required that regulations be grounded in statutory law and an administrative record that is judicially reviewable and includes the opportunity for public notice and comment. Now, the Administrative Procedure Act, the APA, has not been substantively changed in 75 years, aside from a few additions like the Freedom of Information Act, Privacy Act, etc. So now, as long as agencies act within the rulemaking authority delegated to them by Congress and follow those procedures of the APA, recent courts have not found it unconstitutional for them to write and enforce administrative laws. The second milestone I'd like to highlight was the economic deregulation that occurred in the 1970s and 80s. Bipartisan efforts across all three branches of government led to the abolition of whole agencies, including the Interstate Commerce Commission, which was the first regulatory agency established in the 1880s, and also the removal of unnecessary rate and entry regulation. By replacing government price controls, et cetera, with competitive markets, the government was able to generate real improvements in innovation and consumer welfare. So think about cell phones, Zoom webinars, the explosion of air travel. So I think that's an important milestone to think about. The third milestone on my list is regulatory impact analysis. So at about the same time that the economic forms of regulation, which had been predominant during the New Deal and before, at the same time that they were declining, we saw a new type of social regulation emerging. That was aimed at protecting health, safety, and the environment. At the time, concerns over their reporting and compliance burdens led to the next wave of regulatory reform, which wasn't outright deregulation as we'd seen earlier, but on ensuring that regulatory benefits outweighed regulatory costs. So President Jimmy Carter paved the way toward the current regulatory impact analysis requirements. He required agencies to determine the need for a regulation, evaluate the direct and indirect effects of alternatives of regulation, alternative forms, and choose the least burdensome approach. Subsequent presidents have built on those requirements, leading to the regulatory impact analyses that are routinely conducted today for significant regulatory actions. And then finally, the fourth milestone on the road to the modern regulatory state was centralized White House review of regulations before they're issued. Presidents Nixon, Ford, and Carter each had modest programs for centralized oversight of agency rulemaking, and Carter created the Office of Information and Regulatory Affairs when he signed the Paperwork Reduction Act in 1980, but it was President Reagan's Executive Order 12291 that put in place the requirements for executive branch agencies to submit their draft regulations to OIRA, the Office of Information and Regulatory Affairs, for review before they're published. 12 years later, President Clinton cemented these requirements in Executive Order 12866, which I think remarkably remains in effect today, especially when you think of how different those presidents have been between Reagan or Clinton and President Biden. So I could say so much more about each of these milestones, but I will stop there and would love to hear from my fellow panelists.
So Beth, Jeff, additions, quarrels?
Well, not quarrels, but perhaps some additional perspective. I think partly the term administrative state grows up in contrast to the situation at the founding. So if you think about at the beginning of the Republic, the administration of George Washington, let's say, you had three agencies, the State Department, the War Department, and the Treasury Department, and an Attorney General, but no Justice Department. That doesn't come till 1870. So Attorney General is one person. So you have only three departments, and administration in those days is largely what it sounds like. It's collecting customs duties, and it's paying federal employees such as they are. But over time, particularly as you alluded to, starting in the late 1870s with the creation of the Interstate Commerce Commission, there are waves of new regulatory agencies created, starting, as I said, in the late 1870s, but then these big waves after the turn of the century, 1906, the Food and Drug Administration, 1914, the Federal Trade Commission. A lot of this starts with economic type regulation, but also some safety regulation. And then a big wave in the New Deal, where you get the SEC and the NLRB and many others. Big wave in the 1960s with the EEOC and the National Highway Traffic Safety Administration and OSHA, and so a lot more social regulation, safety, and then in the 1970s, environmental, and then another small burst in the 2010s with the Consumer Financial CFPB, a new type of agency because it's not a commission, and the FHFA for housing finance, and some of the Affordable Care Act changes to HHS agencies. So you have these waves. And then the other big development that I would maybe supplement what Susan was addressing is the phenomenon sometimes called presidential administration, growing perhaps late Carter and then Reagan years, and then, as Susan said, kind of solidified in the Clinton years, of the president directing a lot of the agencies as to centralized review for sure, but also coordinating policy implementation through regulation. And then the phrase many people may remember from the Obama years, the pen and the phone approach, where without congressional enactment, or at least interpretation of prior congressional enactments being used to take action that is more quasi-legislative. And more to say about that, but I just wanted to put those on the table as part of the phenomenon that then becomes referred to as the administrative state.
Beth, what about you? Does this narrative ring true and complete to you?
So let me do also what my colleagues have done, which is to augment what's been said. So no fights yet and no disagreements, but I might put the emphasis in a slightly different place or add to what they're saying. I'm the recovering lawyer and law professor on the panel who is currently an engineering professor. So I bring a bit of the tech approach to looking at some of these questions and looking at how we can really modernize developments in the administrative state, which we'll come to talking about in a moment. But let me, by way of background, so that we can understand those developments in a minute, sort of lay emphasis in a couple of areas. One, as my colleagues have already emphasized, the growth in the administrative state is concomitant with the dramatic growth and complexity in governance in our country, especially since World War II. So this is not simply an issue of right or left or the right size of government or bigger or smaller government. We simply live in a very big and very complex country in which government has an enormous remit, and our bureaucracies have grown, as Susan pointed out, very much under Republican administrations as much as Democratic, to really deal with the complex challenges of social and political life. So whether it's issues of green energy or brain science or personalized medicine and public health, climate change, transportation infrastructure, all the things that are in the news these days, our administrative state deals with huge amounts of and very, very complex problems and issues. So some say, and I don't remember who's the origin of this quote, whereas it used to be hard to start a government program, now it's hard to stop one. But I think it's important to recognize that this is a fact of modern life, that we live in a very complex world and a complex society. And that's why there's been this explosion really in the growth of rules that are created by the administrative state. So as people know, Congress, passes a few hundred statutes a year. Federal agencies pass thousands of rules that govern every aspect of the life we lead, from the width of doorways to the speed of our ceiling fan, to the clean air and the clean water that we ingest. And so those rules are an incredibly important part of modern life and of modern governance that really help to effectuate the implementation and execution of laws. Sorry, that's my assistant joining us for a moment there. I think that implementation and execution of law that's done by federal agencies is extraordinarily important. So it's not just the making of policies, it's the inspection of our food, it's the inspection of our workplaces, it's all the work that needs to go on to make that happen. And so what's really helped with that process, and I would add one other milestone to Susan's list, is not only the passage of the Administrative Procedure Act in 1946 that gave us this democratic right to participate in making those rules, but in 2002, the E-Government Act helped us to put those processes online. So that now we have a website called regulations.gov, where you and I and everyone else, whether or not you have a law degree or live in Washington or know anything about the administrative state, has the right to participate in informing how these practices of the administrative state work. And that's what makes them also really, really different than how Congress works, where really the ordinary person has no outlet and no opportunity to participate in governance. I think the milestone of creating regulations.gov, of creating a way for ordinary people to participate in the workings of the administrative state, in the design of those rules, and in the execution of federal policy is really an extraordinary democratic moment that I think few people are really fully aware of, and few people, frankly, take advantage of.
Can I just jump in with one supplemental?
Please, absolutely.
Yeah. I think those are all good points. I'm not jumping in to disagree. I'm jumping into supplement, which is sometimes the scope of the administrative state is not always understood. Some of Susan's work has actually quantified the size of the government, how many employees. I think it's over 2 million, I think, employees in government agencies. And the reason it's important to the pillars of democracy type of concern, I think, is regulations are laws. They have the force and effect of law. And so just to give a quantitative sense of that, in the period between 1995 and 2017, about a 22-year window, there were approximately 4,400 statutes enacted by Congress, but there were 92,000 regulations promulgated by agencies. So it's roughly a factor of 20 times more laws coming out of the regulatory process than coming out of Congress. That's just to give a sense of its importance. It's not that they're not necessarily apples to apples in the sense that some of the congressional laws delegate authorities to agencies, and other congressional laws are to name post offices. But just in a crude sense, to get a feel for how much activity there is, the administrative state is very large and consequential to all walks of American life. And it's not just businesses, it's hospitals, it's schools and universities, it's municipalities, individual citizens. These regulations, which are laws, affect everybody.
Well, thanks to all of you for getting us off to such a great explanatory start. I have a million questions already, but I promise to be a moderate moderator. And so it is now time to move on to the second pre-planned discussion, namely the problems that have cropped up with the administrative state. As Susan mentioned in her opening remarks, what might be called the Charter of the Administrative State was created 75 years ago and has not, I think most scholars would agree with her judgment, been significantly amended. There have been some additions, but the basic structure is very much intact. I suspect that the mind of man is incapable of creating an institution which over 75 years is not exposed to some unanticipated consequences and difficulties. So to begin our exploration of this question, Jeff Rosen is going to lead off. So Jeff, over to you.
Thanks. So, we're going to focus in this part on the problems that have developed in the last 75 years. But I think it's sensible to just remind everybody as we do that, what we just said in the prior segment, which is these agencies were created in response to perceived problems and looking for solutions to them. And as the society and the economy grew more complex, a perceived need to address them. So I just want to provide some context that although I'm going to focus on the problems, I don't mean to ignore the fact that these agencies also address genuine concerns and can do some good, but I'm going to focus on the problem side of the equation. And in that sense, if we think about the Administrative Procedure Act of 1946, it was itself a compromise it didn't solve or even address all problems, but it specifically tried to deal with the problems of due process, of the fact that the governmental agencies were taking on such new and large roles that citizens and regulated entities had certain protections in a procedural way. And but new issues have arisen over time. Some are ones that aren't really addressed by the Administrative Procedure Act, such as the problems of economic costs, and others are changes that have occurred or issues that surfaced as to public participation and democratic legitimacy of the procedures by which things are done. So I think it does bear note that from the beginning of 1946, from the beginning of when the Administrative Procedure Act was passed, there were still concerns, and there were a series of different kinds of reports and commissions. I mean, going all the way back to 1955, the Second Hoover Commission raised a bunch of concerns and had proposals for additional administrative reforms. In the 1960s, the American Bar Association proposed a number of reforms. In the 1970s, the cost concerns started becoming more to the forefront, and there was a commission chaired by Lloyd Cutler, who had been President Carter's White House counsel, called the Road to Reform, that was very focused on the economic costs of regulation. And in the 1990s, some regulatory reform efforts. And over time, there's been perceived to be, I think, a growing disconnect between the 1946 reforms and some of the regulatory realities. Certain procedural protections were eroded in part by judicial decisions. The Administrative Procedure Act had contemplated some formal processes and some informal ones, and the formal ones got narrowed and fell into certain disuse on both the rulemaking and adjudication side of things. But the biggest disconnect by far is the expansion of agency rulemaking and its consequences, especially its economic consequences, but sometimes the perceived policy changes without congressional participation. And in that regard, it's probably worth noting that rulemaking had been something of an afterthought in 1946. That's actually a phrase that came from James Landis, who had been the head of the SEC in the New Deal and dean of the Harvard Law School and was an advisor to President Kennedy in 1960. That rulemaking was originally thought to be something that was somewhat technical. How do you calculate a way to comply with the statute, or what instructions are there for what documentation might be needed? But over time, agencies started issuing very consequential rules, and in recent decades, sometimes rules that involve over $1 billion in expected compliance costs, sometimes much more than that. And at the same time, as I alluded to earlier, presidents came to see the regulatory agencies as another tool of their own policy authorities. And so you got, on the one hand, concerns about congressional delegations and whether they had been excessive in terms of what was being given to the administrative agencies. And on the other hand, concerns about overreaches by the executive branch in terms of its construing what authority it had. And then concerns about public participation have grown over time, both because, as I alluded to, judicial decisions that seem to limit it, that more and more paper proceedings. And so we reached a point where in recent years, I don't have the most recent counts, but the Code of Federal Regulations is about 236 volumes and about 175,000 pages. It would take an individual, if all they did full time was read it, more than 3 years to read it. And that's assuming that they're a relatively fast reader. So that's a lot of rules for people to have to be aware of. There's a famous quote from Winston Churchill in 1949. He said, when you make 10,000 regulations, you erode respect for the law, because people have a hard time even knowing what they are. So again, if we're focusing on the problem side of the equation, and we'll leave the positive side to another conversation, there's 4 I want to flag. So one of these is that rules use private resources. The compliance that's required is private resources. So they function as something of a hidden tax, and the total costs of regulation are estimated in recent years to be as much as 4 times the cost of corporate income taxes. So again, very consequential use of private resources, and used in a way that doesn't have the same constraints that you get with legislation, in that there is no constraint on an agency's decision to require costs to be imposed to achieve the public good that it's seeking to achieve. So that's one set of concerns that grows out of the growth of rulemaking in particular. A second is that the economic impacts are very consequential. Some of the economic research, and these things produce lots of research and sometimes disagreement, but a couple of studies have suggested that the impact on gross domestic product in the years after the APA to the present has been as much as 2% a year in the negative direction of restraining growth. And even if it were less than that, it would still be very important economic impacts. Likewise, one of the things Susan was alluding to is there's concern as to whether there's careful enough analysis as to whether the rules that are being issued, especially the highly costly ones, are rational in the sense of the benefits exceeding the costs. My recollection is that over the last decade, there have been more than 20 rules where the agencies themselves said that the costs exceeded the benefits, but they proceeded anyway, sometimes perceiving that Congress had required them to, and other times that just thinking that they thought the outcome was desirable. A third perceived problem of some importance is the problems of competence and expertise. As the administrative state gets large, its resources are strained, its technical expertise is strained, the volume of activity grows away from core missions. There are concerns about, on the one hand, whether there's enough expertise to perform these things competently and well, and on the other hand, whether there are things being regulated that are not actually technical subjects or things that need expertise, they're policy calls, and why are those not being done by the people's representatives rather than in the administrative state? And then a fourth set of concerns is what I would call accountability and public input opportunity. And that's a perception that there are sometimes procedural shortcuts, of which the big one that gets the most attention is the use of guidance documents, where agencies say, this is our interpretation of what you need to do, but don't have to go through the rulemaking process and then try to hold parties to those requirements without having gone through the full rulemaking kind of process on the theory that it's faster. That's a complicated subject. I won't go through the whole thing here today, but it's the aspect of whether the public has full participation rights and whether the regulatory process is being used to circumvent Congress on things Congress did not act on and had even been asked to act on and chose not to, is the fourth kind of concern. And that takes me to the last point I'll make before I pass the baton here, which is collectively these sets of concerns, I think, lead back to concerns that existed even before 1946, which is fundamental concerns about legitimacy under the Constitution as to whether there is over-delegation or, as I said, on the flip side, agency overreach. And concerns about whether Article 1's legislative authority has been over-delegated, improperly delegated, and in some sense would violate due process. That's been going on. That's been a concern for the better part of a century. But a number of Supreme Court justices have indicated some renewed attention to it as a concern, not necessarily to what the solution is, because the circumvention of Congress and the public is a concern that many have expressed. So I'll pause there, but as I said, I'm trying to put some attention on the problematic side, and I think there are people who are concerned about adjudication. There are people who are concerned about operations of activities, but I think it's the growth in rulemaking that has really led to a lot of the concern about the administrative state.
Susan, Beth, different perspectives?
Let me just add a little bit more to maybe to reinforce what Jeff was saying. I think part of the problem is the incentives that these developments have created, so that Congress has the incentive not to compromise and pound out details, but rather to pass vague statutes that have good sounding goals, but then delegate the details to the regulatory agencies. And then in some ways they get a win when they pass a statute that will, require affordable care or clean air. But then they get another win when the agencies actually go to implement their vague mandates. And if they don't do it in ways their constituents like, they can, hold hearings and things, but they still aren't doing what the Constitution expected our legislative branch to be doing. So it's kind of a complement to what Jeff was saying about how agencies are taking on more responsibilities, but often they're operating under statutes that were not intended for the problem that they're designed to resolve, because that's just hard for Congress to do. And so they can easily pass the buck with these vague statutes.
Beth, you may have a different perspective.
Not surprisingly, but there's no fist fights yet, though. I'm sorry, Bill. We'll try to engineer some to make it more engaging. But I would just emphasize a couple of things. It really builds on what Jeff said about expertise and accountability. I think he was really spot on. And in the fact that we are missing the opportunity to do both in a better way over the last 75 years, and especially since the advent of the internet. So, the reason for the creation of the administrative state is the administrative state is really there to be the eyes and ears of government, as the famous political scientist from Yale, James Scott, in his book, Seeing Like a State, the title is the whole thing. It's about seeing like a state. It's about having that ability to measure on the ground conditions and to really be what Harvard legal scholar Adrian Vermeule refers to as the sensory organ of government. So, agencies and their staffs are there to cull information, to gather information, to really help us to make sense of what's going on the ground, so that in theory, we can create rules and regulations. We can create this body of law that is responsive to problems as they actually occur. The challenge is, and Scott already wrote about this with regard to the state as a general matter, and he wrote about the German bureaucracy and the way that the state tends to simplify and be reductive, and in its effort to measure those on the ground conditions. And I think the challenge is that as a general matter, the state has not caught up with the technologies of the internet, of big data, of communication, that could allow us to really get smarter faster, to see with more acuity as a state, so that we can do a better job of understanding problems and therefore fixing problems. So let me give 4 just quick examples in reaction. First, I'll go back to what I mentioned before, which is regulations.gov, which was meant to be this website to help the administrative state get in better information. So the agencies would get comments from the public in response to draft rulemakings. Effectively, regulations.gov put what was a paper-based process that used to be done by mailing in comments, just put it on the web. So you were given a box, you're still given a box where you type in your comments. And you know what happens when you give people a box in which to type in their comments? Well, either nobody does it, that's one problem, or in some cases, too many people do it. So you'll recall the famous net neutrality rulemaking from the FCC that garnered a lot of media attention. 22 million people typed in the box. And there were two challenges with that. One is, how are you going to read 22 million comments without the tools to do it? And if you do read them, you have the ability then to recognize, as was the case in that rulemaking, that only 6% of those comments were actually original. Almost all of them were just duplicative cut and pastes that had been proposed by interest groups, and then people put them in. So it's just an example to say that the way we're designing the technology for us to actually get information is not very effective. Secondly, and just very briefly here, agencies also rely on what are called federal advisory committees. Those are groups of industry and academic and other experts that are meant to provide input on important issues. Those committees are constructed in a way that predates the internet. They are groups of people who, at least until recently, would have to fly into Washington. You would have 10 or 20 or 12 people who would be on such a committee. And in every, administration, we argue about the composition of those committees, but they're these relatively small groups of usual suspects providing expertise. In the day and age of networks and social media, there's no reason to have 12 people on a committee when I can have 1,000 people on a network and use technology to get in better information faster. There's really no effective way of connecting experts from universities, from industry to agencies in a way that can really help us to shape the solutions and the rules that we develop. And we're not using technology in the way that, frankly, other countries are beginning to do to really take advantage of improving the functioning of agencies. I had the pleasure of being on a Brookings panel a week or two ago. There's a new report out that Brookings put out just on the way that administrative agencies could use artificial intelligence and new technology to do things like spot fraud, waste, and abuse. In Canada and in Brazil, they use this as a regular matter, where if you file a health insurance claim, AI helps to review your doctor's note and make sure that it's not fraudulent. In Brazil, their comptroller uses AI to be able to check and prove spending patterns. It's just one simple example, and there's so many more of the ways in which we could take advantage of new technology to get smarter, faster in the way that we work. So let me stop with that.
Great. So Beth, let me clear up a moderator's confusion. Was what you just presented a sketch of sort of the fixes and solutions talk, or was it in response to the previous question, or some of both?
It was meant, well, you're right that I was segueing into the next part, in which I was going to say a little bit more about what is big data and what is artificial intelligence and how to use them in order to address some of those challenges. But since I already made that segue, if you're eager to jump around, I'm happy to do that. I think the point I wanted to make, though, in terms of the problems, is really just that we haven't modernized in the way that the state works.
Well, my moderator's judgment is that you have created the predicate for your own short discussion of the fixes. And so with the permission of the panel, I think I'm going to move straight to that. And then if there's some catch up to be done at the end, we can do that. So please proceed, Beth.
Oh, well, now I will continue where I left off, essentially, having created my own layup or my own segue, choose your metaphor here, to really saying that we have this opportunity, I think, to use two kinds of technology. And it's where administrative agencies really need in terms of reform. And I think my colleagues will have very different answers here, hopefully, that are both legal and structural. But let me continue on this vein about technology and also about ways of working in administrative agencies. So I think there's two big things really that we need to do. One is to dramatically increase the use of data to help us get smarter. in federal agencies, sorry, and let me not just say federal, we obviously have the administrative state, obviously at the state level and at the local level. What we need the administrative state to really be able to use data to get smarter about problems as they're happening on the ground. And we need to be able to get smarter from people, from the wisdom of communities, from the insights that we get from talking to people about the challenges as they experience them. And in fact, in 2018, Congress passed the Foundations for Evidence-Based Policymaking Act, and it said that we have to have agencies use data more effectively in their policymaking and to measure and improve their own performance. And thankfully, we have the ability to do that today in a way that we could not have done previously. So we all have these things, our phones, that have many sensors in them that allow us to gather data. We're awash in the mechanisms for gathering information. We have, more data that we're generating every day. But we don't have the ability necessarily to be able to use them. So, by some estimates, the amount of data, the kind of knowledge of sort of when we talk about big data, how much is big data? Even a few years ago, and this number is now dramatically bigger, it was estimated that we had created 12 zettabytes of data. And that in a few years, that number is they say will reach 163 zettabytes. And just for comparison, given where we are, the entire Library of Congress is only 15 terabytes. The 15 terabytes, I'm about to buy a computer. I think I just bought a computer that has just about that much memory, which can contain the entire Library of Congress, essentially. So we just have enormous volumes of data that are available to us. We have ever more granular forms of data that we can gather in real time about the conditions that are happening on the ground. And we have lots of different types of data that come from different places, not only data that government collects, but data that companies collect, data that each of us gathers. But what we do is we really lack the tools, the technologies, and the analytical skills within the administrative state that can allow us to take advantage of these tools, that can allow us to do things like spot fraud, waste, and abuse, like I talked about before, figure out how we can spend money better and spend it more efficiently, that can allow us to spot patterns as they're happening on the ground and to spot things like discrimination, as was the case in Ohio, when by looking at the data, they understood very quickly that communities of color were not receiving clean water, whereas white communities on the other side of town were receiving clean water. And we see the same thing in Flint, Michigan, and in other places. So lots of examples of like that. The ability to do things more efficiently. In Chicago, when their administrative agencies inspected restaurants, they used to go down a list, A, B, C, D, and start again, A, B, C, D, until they had a data scientist come in and help them look at various data sets, including incidents of foodborne illness and sanitation and rat infestation, create an algorithm for them that allowed them to change how they inspected restaurants. And they brought down the rate of foodborne illness by 25% in 1 year. So I can give you countless examples like that of the way in which data analytical techniques are allowing us to do things like safety inspections more effectively, but also, and I think importantly, to do something that the administrative state has not been able to do as effectively before, which is to share the information that it collects and that it has access to with citizens, with residents, in order to allow each of us to make better decisions. So you may be familiar, many people here may have used a website created by the Department of Education called College Scorecard, where you can go online and check out the college that your kid may go to and compare the costs and compare the offerings, and they're working to compare sort of data on outcomes of people who go to those colleges. It allows you to make a better decision. And that comes from tools that are created by federal agencies for the public, as well as data that's collected by federal agencies and given out to the public to make better decisions, such as you make every day when you decide with your Google Maps whether to take the bus or take the subway. That all comes from data collected by federal agencies, which are then shared with industry and shared with individuals, new tools that are created to help each of us make better decisions. So let me just say, the ability to use data, number one, And I'll say briefly, number two, the ability to use technology to listen to and hear from citizens, to gain their expertise, to connect with people in universities, to transform how regulations.gov works so that it's a more effective, more efficient system for allowing more people really to participate in the process. In the day and age of Twitter and Facebook, we need to really reinvent how these things work and take advantage of these technologies to allow us to get smarter in how we do things. So let me stop with that to really
Perfect.
just say that the solution here is not only digital skills, but also changing how we work and training people to learn how to use these tools.
So, Susan, Beth has focused on data and information and the way technology can help us solve some previously unsolvable problems. But I suspect that you have a very different focus on what needs to be done to address the problems that all three panelists have put on the table.
Well, actually, first, let me reinforce what Beth said about the importance of data and evidence and actually evaluating regulations that are in effect. We put all our effort on regulatory impact analysis before we issue the regulation. And then we very rarely do the retrospective review to see, did those hypotheses that we laid out in our ex-ante regulatory analysis, did they actually yield the results we thought they would? And I think, the Evidence-Based Policy Act that Beth mentioned, and better data, in fact, planning to have that better data when you write a regulation. Say, these are the outcomes we expect, and here's how we're going to find out 5, 10 years from now and evaluate it, and then change the regulations accordingly. I think that would make a huge improvement. But I also think that to be agile, there are a lot of challenges that we may be facing now for which we do not have data, despite the terabytes that Beth talked about. So to be innovative, we also need to learn to be able to move forward when we can't do a thorough analysis. The OECD just came out, I think last week or the week before, with a set of recommendations on agile regulation. And one of the things that they mentioned, that they talk about, that I think is so important, is experiment on a small scale. So that's the sandboxes, learn by doing, so that you don't put in place a comprehensive regulation based on an understanding we have today about something that we don't know what kinds of things will emerge over the next few years. And along those same lines, instead of focusing on the process to achieve what we think we want, focus on outcomes and maybe do a little more ex post action enforcement if something is, if there's an outcome that we've identified that shouldn't happen. So drones, for example, and Jeff will know a lot about this, having served as Deputy Secretary of Transportation. What's our concern with drones? Well, one might be privacy, another might be hazard, that they fall and hit someone on the head. Instead of spending a lot of effort regulating what the size of the drone should be and what technology it should have, maybe regulations that say, if your drone does X, then you will pay this fine. That kind of ex post outcome-based regulation may be a way that allows this innovation that could really, in so many different areas now, that could make people better off. So that was partial agreement with that.
Thanks, Susan. Jeff, you bat cleanup, although it's an imperfect baseball analogy, there being only three of you, on this question of your favorite fixes for your favorite problems.
Right. So 3 quick observations. One is the question of fixes has been debated in Congress for some years now. And in 2019, the Justice Department had a summit to discuss modernizing the Administrative Procedure Act. So I can't resist the shameless plug to say, if anyone wants to see the results of that summit, there's a report called Modernizing the Administrative Procedure Act that can be Googled and found as a PDF on the Justice Department's website. But I'll short circuit some of that to say there were two big categories of reforms. One are things that are process improvements. of different types, whether they're public participation or additional cost benefit scrutiny of the most consequential rules, or some of the technology ideas, which I am a supporter of. And when I was at transportation, we focused a lot on something called the Safety Data Initiative as an example of that. So process improvements is one. The other is to take the problem of cost directly, some forms of regulatory budgeting to constrain the decision-making and to create incentives on looking at outdated and unnecessary rules in addition to new ones. A number of countries have pursued that path. That's one that initially had bipartisan origins. I think Senator Lloyd Bentsen had been an early proponent of that. And it was, its most recent incarnation was through Executive Order 13771 that President Trump implemented, but which has now been revoked. But I think those two categories of things, process improvements and direct caps on what the cost issues are, as one possibility. And by the way, caps are sometimes misconstrued as though it prevents regulation. It depends where the cap is set. If it's set at 0, that's one thing, but there's nothing that prevents the cap from being set at a higher level for an administration that's more supportive of devoting some compliance resources to that. And that takes me to the third and final thing I just wanted to observe. Just as I was saying, the regulatory budget had originally been a concept with some bipartisan origins. A lot of the reforms over the years have had that kind of flavor. In the 1990s, when the Unfunded Mandates Reform Act was passed in 1995, it got 86 votes in the Senate and 394 in the House. One of the things I had wondered about was, since it tends to be that the party that doesn't have the White House, that folks that are associated with that tend to be the most critical, not exclusively, but just generalizing here, that some of the dissatisfaction that, say, conservatives might have had in the Obama years, liberals had some dissatisfaction in the Trump years with the regulatory, both the process and particularly with the results. I thought, and I still think it's possible, that there could be interest in bipartisan solutions. I think one of the things I'm attracted to on the technology points that Beth's making is I think they have a greater than ordinary capability of attracting interest from people of diverse perspectives. But at least in the near term, I've been surprised at how little discussion and interest there appears to be in regulatory reform. That could just be, that the agenda is crowded and it'll come to the surface. But I think it's one of the things that would be in everyone's interest to look for things that have support from people of differing vantage points, but improve the way the system functions. Because at the end of the day, everybody has an interest in whatever you think the role of government is, that what the things it does well. And so that's maybe where I would stop is on the hope that some solutions that appeal broadly could be found.
Well, I want to congratulate all three panelists on bringing in this first stage of our discussion at exactly an hour, which leaves us up to half an hour for a very large range of questions that have come in. I think a testimony both to the interest and the complexity of the issues before us. And let me summarize a bunch of questions in one before moving on. Jeff, I think you were the one who used the phrase democratic legitimacy to characterize sort of a meta problem for the administrative state. And, I don't think your fellow panelists really disagree with that. And a number of people have wondered whether the extraordinary proliferation, of rulemaking, the size of the Federal Register that Jeff, I think you referred to. Well, doesn't that empower an army of lobbyists and lawyers and experts, engaged in opaque activities that the public really doesn't see or understand? It doesn't have the vividness of clashes on the floor of the House and the Senate, or dueling press conferences. But a lot of business gets done that way. And there are a lot of ordinary citizens in the country who are really deeply suspicious of the way in which the administrative state operates. And it's easy to sympathize with them. So to the panel, is that a problem? And if so, what can be done?
Maybe I'll dive in here to start, and I want to pick up on a point that Susan was talking about earlier with regard to gathering evidence after the fact, not only before the fact, to assess how regulations are working. And to answer your question, in Chile, they have a process that they call Evaluación de la Ley, where they do citizen focus groups after regulations are passed to bring in citizens and to ask them, how do you actually experience this regulation? What is it like for you? So it's not just a big data, think tank analysis. They actually sit down and do focus groups with real people and with regulators to ask, how is this working in terms of the administration of this rule in practice? In the UK, they have something that they call evidence checks. It's a parliamentary process whereby a parliamentary committee goes back to the regulatory agency and it says, put up on the web, tell us what is the evidence that you have that led to the formulation of this regulation or this policy. And it's fully transparent and people can weigh in on it and comment on it. So there's some examples out there, I think, in that we have in foreign jurisdictions, that we have at the state or local level, and that we have, thanks to some new tools, of ways in which we could make these processes less opaque. I think it partly starts with discussions like this one, because frankly, we don't get a lot of coverage of the administrative state. To your whole point about the fact that it's opaque because, it's not the slugfest that CNN likes to cover, where it covers the politics. It loves to cover the sport of politics rather than the substance of governance. It's just not something we talk about enough. And I think it starts, very, very early on with education and with interest. It's tough in this media climate to get people interested in what happens in the administrative state. But I think there are ways in which we could evolve our institutions and create mechanisms. I'll give you one more example. It's not quite on the regulatory side, but in the Belgian region around Brussels, they use a random sample of citizens who are assigned to every committee in their regional council. So again, it's a little more legislative than regulatory, but the concept is there. And similar things have been proposed for federal agencies, where they bring in a random sample of citizens to essentially provide oversight and to watch what they do and to participate what they do. And you have lots of examples around the world. At least 1,500 different communities have started working with groups of citizens to do what's sometimes called participatory budgeting, to decide how the state spends money. Should we build a playground or should we build a soccer pitch? And I think those kinds of innovations give us some ideas about ways in which we could do things differently that would help to remedy some of the problems of democratic legitimacy that Jeff really talked about.
I still have a problem. This is now for Jeff or Susan. There's still a lot of people who talk, for example, a familiar phrase about unelected bureaucrats. Mm-hmm. Right. And there's an aura of suspicion that's encapsulated in the adjective. And there are others who can't say the word regulation without preceding it with the adjective burdensome. And all of these problems are swirling around. I think I've just summarized two familiar critiques on the conservative side. Beth has already addressed a familiar critique on the more liberal and progressive side, having to do with democratic legitimacy. So imagine both of you are at least in touch with the conservative world. I think it's fair to say. What's the best way of addressing the problems of democratic legitimacy that turn up on that side of the aisle?
I can say something brief, Jeff, and leave you to say something substantive. How about that? One thing I would like to see is more legislative involvement. If you look, when I talked about the milestones, the APA bipartisan support, really, it took a long time and they pounded out a compromise. It wasn't perfect, but it was a compromise. The economic deregulation of the 70s and 80s, that was definitely bipartisan. Senator Kennedy held hearings on the effects of airline and trucking regulation. Jimmy Carter started to act on regulation, and the agencies that were issuing those kinds of regulations. So that was all bipartisan. My latter two milestones are purely in the executive branch. So the requirements for analysis, all the stuff that Beth was talking about where we need evidence, Congress isn't, I mean, they did pass the Evidence-Based Policy Act, but I would love to see Congress step in and say, it's important to do retrospective review. It's important to do analysis before you issue regulations. So some of the stuff that's been happening in the executive branch, if that were codified in Congress, I think that could be provide more democratic legitimacy.
So, Jeff?
Well, I'm going to augment that I think some of the problems of concern about the administrative state, excuse me, are actually problems of Congress. I think we've seen a massive abdication by the Congress as to the regulatory issues. That not only is there little attention to the regulatory process and ways to improve it, not only is there limited, if any, attention to implementation of statutory assignments to agencies, there's also not even oversight. I mean, I just think back to 20 years ago when I was in an earlier administration, we knew with regulations that there would be some attention paid to the relevant congressional committee, that there would be at least trade press, if not a wider press interest. And I would say in recent years, there's just nobody paying attention. They've abdicated. I think that's going on now. I think this may be part of the earlier series that you had on the Congress, where there's this evolution more towards a parliamentary kind of approach, and also some, if you like the ends, you don't complain about the means. And I just think there's some real problems in the legislative branch, because when we talk about democratic legitimacy, that's where the issue's coming from, is we have regulatory bodies that are part of the executive branch, Article 2 of the Constitution, implementing power and authority through the rulemaking process that the Constitution assigns in Article 1 to the people's representatives in Congress. And people can debate which is the bigger problem. Is it executive branch overreach, or is it congressional abdication? I think there's some of both, but the congressional abdication is clearly part of the problem on the democratic legitimacy concern.
Yeah, well, if I can step out of my moderator's role for just a second, I would say that politics, like nature, abhors a vacuum. And if one branch ceases to function as the Constitution envisioned it functioning, the pressure, in this case, the legislature, the pressure on both the executive and the judiciary to get more involved in the process of legislating than the Constitution contemplated becomes very, very powerful. And so I absolutely agree that a Congress that was more competent on both the legislative side and the oversight side has a really important role to play in ameliorating some of the problems that have been put on the table. But I'd better get back into my moderator's role because there are a lot of questions here. Susan, did you want to?
Well, and maybe I'll put your moderator hat on my head just for a minute. I'm curious what the three of you think about the role for the judiciary in this democratic legitimacy question?
Well, I'm not going to answer that question, although I have some views. But Beth, Jeff, want to think about it?
Well, the reason I'm not jumping in is just it's such a big issue that it doesn't lend itself to a 2-sentence answer for me.
Fair enough. Okay, well, then let me get to the next audience question, and which is another public question. I think many people have noticed that China can build entire cities in less time than it takes us to complete environmental impact statements. And one of the big things on the table now in proposed legislation, which may well become law, has to do with ramped up investment in infrastructure. But there's a lot of evidence suggesting that the regulatory apparatus of review around infrastructure projects is causing delays and raising costs. And many people are worried that it's just too darned expensive for us to build public projects per unit, whether you're talking about a mile of subways or half a mile of bridges or what have you. So is this a problem? Have we struck the wrong balance between achieving the objectives of legislation and translating legislation into a regulatory and review environment?
I'll jump in first here. Another question that's hard to answer standing on one foot in a minute here. But I think the question is really spot on, and this gets back to something that Jeff mentioned earlier in one of his remarks, and that is that, look, we're about to, even with cutbacks, we may be about to spend more money than we've ever spent since World War II. And yet we have declining rates of trust in the ability of government to actually deliver on how it spends this money. There is a concern the government is just not up to the task, which is what your question suggests. And it's reflected in the numbers that you see. And, my colleague Paul Light regularly puts out his data on perceptions of government, and Americans want government to work better. They want reform. And yet, curiously, and it's in part because the oxygen is so taken up right now with the focus on spending bills, that we're not talking about government modernization. We're not talking about how to improve the function of the regulatory state to be able to do this kind of work. It's curious to me that we are the government is the largest employer in this country, and yet we have no training strategy. If I go to IBM, I am required to learn modern techniques of management, including how to engage with my customers, human-centered design, in order to deliver solutions to problems. If I go to AT&T, I have to do 250 hours of training. If I go to a regulatory agency, I have to learn constitutional basics and workplace safety, and maybe I have to do sexual harassment and cybersecurity training, but there's no one who teaches me, and I'm not required to learn anything about how to do a better job of doing the kinds of inspections you're talking about, of doing the kinds of planning that you're talking about, of writing an environmental impact report in a way that's more effective using new tools or technologies. So I think we're grossly underinvesting in public sector upskilling and public sector modernization. And it doesn't make sense to me that we are silent on these issues of what's going to happen after we pass these budgets about how we're actually going to spend that money. So I think that's a real gap. In addition to the challenges really that Jeff pointed out about Congress kind of kicking the can down the road and not really playing an effective role in oversight is, I think, a really major structural issue as well. But another big one is just the failure to invest in modernizing the state. And I think that occurs for a lot of there's that silence is there for a lot of reasons, but I'm curious what my colleagues have to say.
But note the paradox here. On the one hand, there are complaints about government slowness and inefficiency and cost as a result of the regulatory process. On the other hand, when something goes wrong, And, a lot of people get sick, or God forbid, some people lose their lives, or other public ills occur. And a hue and cry goes up. Why wasn't anybody anticipating this? Why wasn't anybody on top of this? And so we go back and forth between the language that complains about overregulation and equally powerful language, usually ex post rather than ex ante, that talks about the consequences of inadequate regulation. So I know this is a very generic sort of question, but it's also, I think, the way a lot of people who are not experts in the administrative state see the problem. We seem to be oscillating back and forth between too much and too little without finding a point of equipoise that we can stick to. So Jeff, Susan, and Beth, if you want to comment on that too. I mean, this question has arisen in a couple of the questions from this audience. Overregulation, underregulation, what?
Well, obviously, some things are in tension, and maybe a good example is the thing you were alluding to earlier on the permitting processes. That if we're going to, for example, have a major new spending on various types of infrastructure, will it be self-defeating to have a regulatory process that says you can't actually build anything till you get your permits 10 years out? And that is a real concern. I think when I was at the Department of Transportation, I guess 3 and 4 years ago,
how time flies when you're having fun, huh, Jeff?
Yeah, right. We were part of an interagency process, but we weren't one of the important players in trying to speed up the permitting process in a process that was called one federal decision, meaning all the requirements had to be applied, whether they were environmental or any other kinds of requirements, endangered species and so on. But it required the coordination to begin immediately and have hard deadlines such that there would be a go, no go call within 2 years. And I think that was an important process to avoid waste, right? Because one of the worst things is that if both the government and private sector actors are investing money for a decade, and then the answer is it's not going to be approved for environmental or other reasons, that's a bad outcome. It's much better to get to that outcome much sooner if that's the outcome. And conversely, if it's going to be approved, the public should see the benefits as early as possible. So I do think there's a need for regulatory improvements on things like that, because I think what you just highlighted is that there's tension in some of these regulatory processes as to how is the government going to implement things in a more operational way, let's say, to actually fund and get something built, while also fulfilling regulatory responsibilities. And that goes back, I think, a little bit to what I was saying before, the importance at the front end of legislation to be thinking about implementation. And that's also where, to agree with Beth's points, we're thinking about modernizing implementation and using newer tools and data and technologies is important. And if Congress doesn't understand it, then okay, delegate that to someone who does. but those things have to be thought about at the front end.
Susan, here's a question for you. As I listen to you, you seem to be giving a pretty full-throated defense of the use of cost-benefit analysis in regulatory matters. Perhaps I misunderstood you, but it sounded like a very positive presentation of that shift in our basic regulatory approach. And this is a question for all three panelists, but I think it's especially relevant for you in your capacity as the former leader of OIRA. A lot of people I know have raised the following question. If you're talking about costs and benefits, and costs and benefits frequently involve things like human health and even human life, how do you put a price on the value of health as opposed to disease, or life as opposed to death? Where does that come from? How can you really do cost benefit analysis unless you make some assumptions about what those things are worth?
You're making those assumptions whether you try to quantify it or not. So when you're making these decisions, we're making trade-offs. So I was also president of the Society for Benefit Cost Analysis. So I have to
I didn't know
caveat
that,
us there too. You didn't even know there was a society, I bet. But I would like to emphasize that regulatory impact analysis is more than benefit cost analysis. It starts with a series of questions, including that very first question of, is this something, and this I think both Beth and Jeff alluded to, is this a core government responsibility? Is this something the government needs to intervene on? And then consideration of alternatives, and then laying out to the extent that you can, the likely good consequences, bad consequences of those different alternatives. And so it's really an accounting, a transparent accounting of what you know ex ante about what would happen under different approaches. That to me is extremely valuable. Whether you have extensive data or not, as long as you're transparent about it, that increases legitimacy in my mind, because it says, here's why we made these decisions. The other thing I'd like to add is that while presidents have all required that, going back to before Reagan, the decision, as Jeff points out, isn't always just based on that analysis. These decisions are made on a range of things, and it includes qualitative considerations as well as the monetized values.
Beth, let me put this same question to you, and then Jeff I think will get to deliver the last answer of this session. I put a question to Susan about the value of health and life, and she turned it back, and said, well, whether or not you specify, you're always making assumptions about that. Do you agree with that? And if so, is that a problem for public purposes? Is government always in the business of doing what Ken Feinberg had to do famously after 9/11?
I'm just wishing I had actually watched the Netflix movie last night instead of what I ended up watching, so I could answer the question. This is, and I'm actually very curious how Netflix has managed to turn cost benefit analysis into a 2-hour entertaining movie, so that we can answer that question. But I think there's a very philosophical answer to this question, which goes in the category of things we don't have time to answer. But there is a way in which indeed we need to be able to, at the very least, venture solutions to challenges that we face. The worst thing that we can do is to leave challenges unaddressed, whether it's climate change, chronic challenges like climate change, or widening economic inequality and racial inequity, or whether it's the urgent problems of COVID and other very acute challenges. The state needs to act in an effort to improve people's lives and to improve people's well-being. And Susan made a point earlier about the need to be more agile in how we do that, to get faster, not, as Zuckerberg says, at failing fast, but at fixing things faster, by doing things and seeing what works, and in developing a more rapid cycle of learning so that we can improve how we do things. And I think that's where we really have the ability to get more agile, more experimental, more creative, and to learn from our experience in the ways that do things better. So it's not fully an answer. If you're asking me the question, how much is a human life worth? I don't have the answer to that question. But I do think that in the work that agencies do to try to improve people's lives, we need to be in that state of constant learning and improvement, which requires really more effective listening to how people are experiencing what the state does for them, how they actually experience those challenges. So whether it's trying to fill out a permit as a business or trying to apply for food benefits as an individual, too often these interactions and transactions with the state are cumbersome and burdensome in ways that they don't have to be, and in which we have the ability now to make people's lives better. And that's what the state, as we saw during COVID, we've had a lot of failures, but we've also seen a lot of ways in which state institutions have been able to improve people's lives. And so I think that's where we need to get better. And it requires more.
Jeff?
So one of the problems that's faced in all realms of life, in government, in business, in the nonprofit sector, wherever it is that resources are not unlimited, that there's constraints. And so an important part for everybody, but including in government, is trying to figure out the best allocation of the resources that are available. So the way I think about cost benefit, while there are people that are truly expert in the quantification and the rigor of the economic analysis, I think of it as just a first critical screen of, is the proposed solution doing more good than harm or more harm than good? And that seems to me always to be a sensible initial screen, because good intentions at allocating resources that in fact do more harm than good are irrational, harmful use of resources that serve the public poorly. So that's why I think the cost benefit issue is sometimes not well understood. It really comes down to just asking, is this going to do more good than harm or more harm than good? As Susan alluded to, that's not always the last screen. It's an important screen to have in the process, but it's also important to ask in broader context of if our resources are constrained, if our time, people, dollars, and everything else are limited, where do we get the most good? Where can we do things that are appropriate? And apropos of the administrative state, with respect for the legal institutions we have, the constitutional system we have, the proper roles of people, so that we are protective of other values, including, in particular, our constitutional system. And so maybe that's where I stop, is that the problems of the administrative state are both economic problems, but they are also problems of how best to implement our democratic system.
Well, that is not only where you will stop, but where I will stop and the panel will stop. But in addition to thanking the panelists for a sober, expert conversation that has, that I think has informed all of us, I want to say that the ratio of light to heat in the past 90 minutes has been a welcome breather from the very different ratio that prevails in so many conversations in Washington. You come from different experiences and to some extent different points on the political spectrum. But I think this has been a model of how civic education can occur, not just for the kids in our public schools who aren't getting enough of it, but also for the rest of us who don't get enough of it either. And so speaking for Brookings, AEI, and the Library of Congress, as well as to the many, many people who have tuned in to listen, let me just say thank you for surely any reasonable cost-benefit analysis would judge that the past 90 minutes have done more good than harm, and therefore there ought to be more of it. Thanks so much.
Thank you, Bill.
Thank you. My colleagues on this panel and the audience, and especially Library of Congress, Brookings, and AEI for having me.